This is Michael Popok, Legal AF. Look at the glasses. Look at the time. It's time for Legal AF After Dark. Jack Smith, very busy. We thought he was just needed a couple of extra days to get the ducks in a row about how he was going to address the new indictment against Donald Trump in the DC election interference case. But no, he also had time to file a masterful rebuke of Judge Cannon in the 11th Circuit, telling the 11th Circuit that Judge Cannon fundamentally does not understand how to do her job. I mean, I'm paraphrasing, that she doesn't understand that the United States Supreme Court and its rulings about the legitimacy of special counsels, just like Jack Smith, is law of the land and binding on her, even in Fort Pierce, Florida. We tell you more. We analyze more of it on Legal AF. Take a listen. And now we're going to dive into the other half of Jack Smith, the walking and chewing gum at the same time, a filing at the 11th Circuit. I'll kick this one off, and I'll kick it over to you, Kara. Does that make sense? All right. So Jack Smith has told the 11th Circuit, in no uncertain terms, that Judge Cannon fell asleep in judge school, where they taught her that the Supreme Court reigns supreme, and if they make a decision in a case and they make it clear that they're not making any assumptions and they're making a fundamental decision that applies to an issue that's before you in your court, you have to follow the United States Supreme Court, just as Judge Cannon has to follow what her bosses at the 11th Circuit just above her say. She can't ignore it. She can't make new canon law. She's got to follow it. It's called hierarchical stare decisis. It's the stare decisis part is you got to follow the precedent and you got to follow what your bosses say above you. What did Judge Cannon do wrong? Well, she did a little thing wrong called ignoring a over 50-year line of precedent starting with U.S. versus Nixon, the last time we had a corrupt criminal president, which generated a lot of case law. And in that case, the Supreme Court validated the existence of a special prosecutor, which is effectively what a special counsel is. And whether you call it a special prosecutor or a special counsel or an independent counsel or rose by any other name, is a prosecutor. And that's the point that Jack Smith has raised. And that the Supreme Court declared that Leon Jaworski, the special prosecutor in the 1970s in the White House case against Richard Nixon and everybody else in his dirty band of tricks, had subpoena power, had power to prosecute. That can't be ignored. And that's what she did wrong. She said, well, there's so many different names for the prosecutor. There's an independent counsel, and sometimes they're called a special counsel. Sometimes they're called an independent counsel. It's so confusing, I can't follow it. So I'm just going to say that this person is not a legitimately appointed inferior officer of the Attorney General. What is she talking about? Since 1909, the Department of Justice, through its powers afforded to the Attorney General under Article 2 of the Constitution, has fleshed out the Department of Justice. Where does she think 23 departments, 8 divisions, and the rest, where does she think thousands of workers in the Department of Justice have come from? Most of them prosecutors, if not by the proper appointment under the inferior officer clause of the U.S. Constitution. So she's off on a wrong foot and she never catches up. Special Counsel Jack Smith is an inferior officer appointed by the department head of this case, in this case, the Attorney General of the Department of Justice, to prosecute cases. That's what he is. And that's who he works for. And that's who he reports to ultimately. And that's who he has to consult with. And that's what his paycheck says. Paycheck says Department of Justice. He doesn't get a 1099. He's not an independent contractor. He's not some stranger to the case the way that Clarence Thomas suggested or she adopted. And he's funded appropriately by legislative action that took pains when they repealed the independent counsel law back in the 1990s, when both sides of the aisle hated what Ken Starr did in the Whitewater going after Clinton. They were like, yeah, we don't need this independent counsel rule. Let's let the Department of Justice, through its inferior officer appointment clause, handle it themselves, but they kept the funding intact. They basically said, we're getting rid of the counsel law, but the funding stays alive. This indefinite funding. Doesn't have to be sought every year. Anytime the Department of Justice wants to exercise its right under its guidelines, adopted ultimately by Congress through the CFR, Code of Federal Regulation, to appoint a special counsel, which is what happened here, they're funded. They're funded out of the Department of Justice's budget. That's it. This is not complicated. What I just did in 4 minutes, Aileen Cannon in 93 pages couldn't get right. And now with the 11th Circuit filing, you have it. Let me just read 2 parts of it, then I'll turn it over to you, Karen. This is my favorite. These are my favorite parts. So under the statement of the case, they love taking her to task by saying that there's been some version of a special prosecutor since the 1870s. Okay? And the naming of it, the nomenclature doesn't matter what we ended up calling it. And she puts undue influence or weight on the naming or the funding or the this and the that, and ignores the U.S. versus Nixon precedent. This is what they said. The Attorney General validly, this is page 8, the Attorney General validly appointed the special counsel, who is also properly funded. In ruling otherwise, the district court, that's Cannon, deviated from binding Supreme Court precedent, misconstrued the statutes that authorized the special counsel's appointment, and took inadequate account of the long-standing history of the Attorney General appointments of special counsels. Oh, that's all she did? Okay. They then lead off with U.S. versus Nixon. And this is what they say on that. In 1974, the Supreme Court, this is page 8 again, determined that the Attorney General had statutory authority under 4 different sections of the U.S. Code. Section 28 U.S.C. Section 509, 510, 515, and 533. That's the recurring theme in the brief. That those same sections, 09, 10, 15, and 33, are the power that come down from the U.S. Constitution, Article 2, through Congress, to empower the Department of Justice and the Attorney General to do just what they did. This is what it says on page 8. Apart from the district judge below, district court below, that's Judge Cannon, apart from her, every court to consider the question has concluded that the Supreme Court's determination that those statutes authorized the Attorney General to appoint the Watergate special prosecutor was necessary to the decision that a justiciable controversy existed and therefore constitutes a holding that binds lower courts. In other words, every judge in America, in jurisprudence, in federal practice, that has had to deal with the issue since 1974 has found that Watergate stands for the proposition that the special prosecutor, special counsel, independent counsel is a proper creature of the Attorney General and is not illegitimate, including the Supreme Court in more recent decisions that also could have been cited. So I could go on, including the references to things that happened in 1909, in 1870. I mean, on pages 12 through 13, they go through that long history of the Attorney General appointing the lawfulness of the special counsel's appointment. This is just a fundamental rebuke to Aileen Cannon. The only thing that surprised me, and I'll leave it on this, and you can pick up where you like, Karen. The only thing that surprised me, maybe it shouldn't, is that I thought at this moment, after 3 separate fundamental misapprehensions of the law by this judge from before the indictment and now with the indictment, including dismissing the case because she found the special prosecutor, special counsel to be invalid for the first time in 200 years, would be grounds for Jack Smith to say, at least in a footnote, maybe it's time for the 11th Circuit to consider reassignment of the case to a different judge. He doesn't do that. Doesn't mean they can't do it on their own, but he doesn't ask for it. Just like your old office didn't take a position, although I thought they did, in sentencing of Donald Trump and all of that. What do you pick up with it? What do you make of what did you pick up from it? And what do you think about why Jack Smith didn't go for the jugular and ask for her removal?
So, I'll start with that. That was the thing that surprised me too. A lot of us were wondering, is he going to ask for the recusal? But I am sure what the Department of Justice did is they went through every single time any Middle Circuit appellate court ever removed a judge, right? And gave it a case to another judge. They went through every single one, I'm sure, in the history of the Department of Justice and looked to see, is it something that you have to ask for, or is it something that they do on their own? And I am sure whatever they found informed how they were going to handle this. They don't want to look biased in any way. They don't want to make this about Judge Cannon. They want to keep this about the law. And certainly the 11th Circuit knows that they can remove the case from Judge Cannon. They know they have that authority, and they know that she has literally been lawless several times throughout this case, and so they don't need to be told or requested in order to do that if that is something they are so inclined to do. So I'm sure that's what Jack Smith wants to keep this about the law and not make it personal. That's what I picked up from that. But yes, it raised an eyebrow for me as well when I saw that. I was certainly looking for it. The only thing I'll add to what you said, which is an excellent recitation of where we are in this case, is first of all, I enjoyed reading this. I've enjoyed this because, number one, it's really a lesson. It's like a history lesson in special counsels and the Constitution and the Appropriations Clause and the Appointments Clause and inferior officers. And, it's just been a very interesting time to be a lawyer, because so many things that we have taken for granted and do take for granted, it all comes from a place. It all comes from a source. And so when you have to go back and refresh your memory on these things, because last time you read the Appointments Clause or the Appropriations Clause was in law school, it all starts to really make sense. And I thought that that Jack Smith's brief really did a great job at explaining in normal people's terms why Judge Cannon's position is illogical, makes no sense, and really just strains any semblance of logic and reason. Although you're right about stare decisis and precedent, she was essentially, Clarence Thomas wrote her a love letter, as you called it, inviting her to make this decision, right? And it's spelling it out for her. So she knows who her bosses are, and he's one of them, right? And so this was very much written for him as much as it was anybody else. He gave her permission to do this. So I think that's why she felt emboldened to do this. And don't forget, she did it on the day before, the day after he was, the attempted shooting of where he got nicked in the ear with shrapnel, and the day before, the day of the convention is when she, basically gave him this gift of dismissing the case. So. But the thing about it, my favorite part of it is just how ridiculous and illogical it is. The position she's taking, which is that special counsel would be okay if you appointed him from within the Department of Justice. The person had to be already an employee. But the fact that you pulled him from the outside, then it's not okay, and that just seems ridiculous. Because, of course, the Department of Justice can appoint AUSAs, the special assistants who are the thousands of people across the country who prosecute these crimes. And, of course, they can even, they can appoint, the president can appoint United States attorneys, and all that. There's all sorts of units and bureaus, et cetera, within the Department of Justice, right, that they create, and none of those have to be approved by Congress. And so, just to make it so that the special counsel is somehow different than that really just makes no sense. So I thought that they did a really good job at explaining that in this, and to show how this is kind of an absurd position that she has put herself into. So I think the 11th Circuit will very, very quickly and expeditiously rebuke her on this. That's my feeling.
Yeah, I agree. And I think they by the prosecutor remaining agnostic about reassignment, I mean, it is what it is. And if the 11th Circuit and the 3-judge panel, which has not yet been assigned, but I'm hoping that William Pryor, the chief judge, is part of it. If they think it's time for her to go under the reassignment power that they have under the statute, then they're going to reassign her. This would be a perfect time to do it. It's like in there, I will assure you that in the history of every person on the 11th Circuit, they have never dealt with a case where a federal trial judge has dismissed the case and closed the case on the indictment because she found that the prosecutor was improperly appointed. Exactly zero amount of times. So they have the grounds to do it, and he could just stay neutral. And this way, it doesn't play into the hands of the lawfare and the weaponization and boo-hoo election interference. It's like, we didn't even ask for it. We just said remand back to the trial judge with instructions, but they're going to do what they're going to do. And we're going to continue to follow it. Welcome back. Every Wednesday and Saturday, 8 p.m. Eastern time, right here on this YouTube channel, you'll find a show we call Legal AF. We named it that 4 years ago, and now you know why. We sit at the intersection of law and politics so you don't have to, and we bring it to you as practicing lawyers from our vantage point with a good educated guess about what's going on with our opinion, like no other show on YouTube. I'm confident about that. If you like what we're doing, see the full-length episode. It's 4 or 5 stories at that intersection of law and politics brought to you just that way. Wednesdays, I do it with Karen Friedman, Agnifilo. Saturdays, I do a show on the weekend called Legal AF as well with Ben Meiselas. And then on hot takes like this, I don't know, about every hour on the MeidasTouch network. If you like to watch us record this YouTube, you can watch us right here on this YouTube channel, and you can live chat with us. If you instead want to listen to our audio version of Legal AF, just plug Legal AF into any of your audio podcast platforms and you'll find us. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.